Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today's video is part of our news session, which we have divided into two parts. The first part will address two key issues central to the Spoken Injustice cause: compensation for wrongful convictions on one hand, and the role of private prosecutions on the other. We will catch up with Michael O'Brien and his efforts to challenge deductions for saved living expenses from miscarriages of justice compensation. We will also examine the actions of the Post Office and the RSPCA, two prominent private prosecutors, to illustrate why such private prosecutions should be halted. In the second part, we will focus on Lucy Letby, discussing her second application for permission to appeal following the retrial in Baby K and other recent developments. So grab a drink, settle in, and get ready for an eye-opening session you won't want to miss. Let's begin with the topic of compensation for miscarriages of justice. You may have seen our recent short video highlighting the obstacles that victims of wrongful convictions face in overturning their convictions. These often involve numerous failed appeals, years in prison, multiple applications to the Criminal Cases Review Commission, and extensive public campaigns to support these efforts. Yet, even after convictions are overturned, the challenges don't end there. Mr. Markinson told The Guardian in May this year that while the public might think he had been paid millions by the state after he was exonerated last summer, he was still living in penury as he navigated the compensation system. He revealed how he found himself in line at the local food bank and how he was encountering nothing but barriers in accessing compensation because of the way the law has been set up. In April, the government published a paper in which it revealed that out of 591 applications received between April 2016 and March 2024, only 133 were accepted as eligible. 460 were in fact rejected. Of the 133 eligible applications, only 39 succeeded. The paper also revealed how, on average, it took 127 weeks, almost 2.5 years, from application receipt to compensation payment. In our video, UK Justice Compensation Europe's Worst, we highlighted how the UK ranks among the worst countries in Europe for justice compensation, requiring proof of innocence beyond a reasonable doubt to qualify. Overturning a conviction is not enough. To add insult to injury, those who are lucky enough to receive any compensation, several deductions are made to their final award, including, up to the 6th of August 2023, saved living expenses, whilst wrongly kept in prison would have been deducted. This deduction, a true affront to justice, was finally eradicated with a policy change by the former Lord Chancellor Alex Chalk in August 2023 at the wake of Mr. Markinson's overturned conviction. However, as we shared in our August news session, Michael O'Brien argued that this policy change should be applied retrospectively. Past victims of miscarriages of justice who faced this barbarous deduction in their compensation should now be reimbursed in accordance with the new policy. However, on the 5th of August this year, an official of the Ministry of Justice wrote to Michael's solicitors, having carefully considered your request on the issue of saved living expenses deductions, ministers have decided not to apply the current policy retrospectively. Michael told us how frustrated he felt at this decision, but he was committed to challenge it. It has now emerged that he, together with Paul Blackburn, another victim of a wrongful conviction who spent 25 years in prison and went through multiple appeals before his conviction was finally overturned, have filed papers at the High Court to contest the Minister of Justice's decision not to apply this new policy retrospectively. Among others, both O'Brien and Blackburn claimed that the Ministry of Justice's decision not to apply the policy retrospectively is first and foremost unlawful, as in breach of Article 14 of the European Convention on Human Rights, as it discriminates between victims of miscarriages of justice who received compensation prior to the 6th of August and those who received such award after the 6th of August 2023. They also contend that the decision is irrational, particularly in light of the fact that no reasons were given for the refusal. We commend their efforts and determination and hope their voices are heard. Now, turning to another critical issue impacting our criminal justice system, one we have explored extensively and even dedicated a specific playlist to: the matter of private prosecutions initiated by powerful organizations. In particular, today we refer to two of the most prolific serial private prosecutors of the past few decades, and which have come under attack recently: the Post Office and the RSPCA. Their conduct describes precisely why we are so averse to private prosecutions. There is little need to elaborate on the conduct of the Post Office, as the Post Office Horizon IT inquiry has already done a thorough job of exposing its action. The RSPCA, however, has largely escaped similar scrutiny and has somehow stayed out of the spotlight. Yet it has recently come to light that they too have preached well but acted poorly. This is what happens when you don't practice what you preach. The Post Office has prosecuted and convicted hundreds of sub-postmasters for theft and false accounting. Yet, when asked what happened to the money that the sub-postmasters were forced to repay for non-existent shortfalls caused by a severely flawed IT system, no one seems to know how this was accounted for. Speaking of false accounting, similarly, when the RSPCA, overstepping its role, decided to prosecute puppy sellers for fraud and misrepresentations to the public, they were simultaneously misleading the public themselves through their assured scheme. On the 26th of September 2024, following animal welfare activists revealing secret filming on RSPCA assured farms, which showed breaches of legal standards and regulations, including overcrowding, poor hygiene, and physical abuse of livestock by farm workers, an open letter calling for an immediate end to the scheme was sent to the RSPCA, signed by 60 animal welfare organizations, including Animal Rising, Animal Aid, PETA, and Animal Justice Projects, alongside celebrities including Ricky Gervais, Joanna Lumley, and Brian Adams. The letter said the scheme was welfare washing animal cruelty and misleading the public. Misleading the public? Isn't that fraud? On the same day, Vice President Brian May offered a letter of resignation in which he said, in relation to complaints that had have been levelled in recent months at the RSPCA over appalling bad standards of animal welfare in member farms of the RSPCA Assured scheme, I find the RSPCA's response completely inadequate. I feel the only acceptable policy would have been complete dismantling of the scheme. Instead, the RSPCA have tried to defend their position and in doing so, in my view, have sacrificed their integrity. Such conduct is far from what we should expect from those in prosecutorial roles. Prosecutors hold a position of immense responsibility and trust, and their work directly impacts lives, reputations, and the integrity of the justice system itself. Integrity and candour are the cornerstone value that all reputable prosecutors must uphold, guiding every aspect not only of their work, from gathering the evidence to the fairness of trials, but also as their overall conduct, consistently upholding high ethical standards. Without these fundamental qualities, prosecutorial actions risk being tainted by bias, overreach, or injustice, which can erode public confidence in the legal system and undermine the pursuit of true justice. The issue is that these private prosecutors are unlike any others. They are powerful organizations that command significant respect from those in position of trust within the criminal justice system. If the RSPCA or the Post Office suspect you have committed an offence and approach the police for a warrant, the police will unlikely raise any questions. However, if you, as a private citizen, were to approach the police tomorrow and request a warrant against the RSPCA or the Post Office so that you can conduct a prosecution against them for fraud or false accounting, it's unlikely that you will get anywhere with that. Perhaps this now better explains why we are so strongly opposed to this type of prosecutions. The issue lies not only in the power and influence these organizations hold, but also in the significant imbalance they create within the criminal justice system. When private entities like the Post Office or the RSPCA can wield such authority and effectively bypass standard legal scrutiny, it raises serious concerns about fairness and accountability. These organizations, with their vast resources and established influence, are able to initiate prosecutions with little to no pushback, while the average citizen would face overwhelming obstacles if they try to hold such powerful institutions accountable, as we have seen in the Post Office cases. This power dynamic undermines the integrity of the criminal justice system and creates an environment where certain entities practically operate above the law. Of course, the Post Office now states in its website, the Post Office has not undertaken any private prosecutions related to Horizon since 2015 and has no intention of doing so in the future. In cases of suspected criminal activity, evidence is referred to the relevant law enforcement agency. As per the RSPCA, despite an announcement made on the 28th of January 2021 that it would stop bringing private prosecutions, this is yet to happen. The transition to pass over prosecution to the CPS is still undergoing 3 years later. According to the Countryside Alliance, in an article published in November 2023, 2 years later the RSPCA is still prosecuting, whilst its prosecuting oversight panel says it is preparing the transition of its prosecution operation to the CPS. In reality, that transition is much more about the parting of the society's long relationship with the criminal courts rather than the practicalities of the CPS prosecuting animal welfare cases, which it already has a statutory duty to consider. For its own benefit, the RSPCA needs to accept that relationship is over and walk away from further damaging court cases as soon as possible. However, without legislative action, there is no guarantee that these powerful organizations or other with similar influence and standing won't continue to pursue prosecutions. This is why we strongly urge Parliament to take steps to prevent these organizations from initiating private prosecutions and to limit the scope of Section 6, subsection 1 of the Prosecutions of Offences Act 1985 in accordance with our reform proposal. Details of this proposal can be found on our website and in our video Private Prosecutions, a Growing Cottage Industry, both of which are linked in the description below. Discussing the integrity of the criminal justice system leads us naturally to the second part of this news session focused on Lucy Letby case. However, before we dive in, if you are finding this video helpful, please give it a like and consider subscribing to our channel. Your support helps us reach a wider audience and further our mission to humanize our criminal justice system. Thank you. So, as promised, this second part of this news session focuses on the latest on the Lucy Letby case. We have provided a detailed timeline of Letby's prosecution and an in-depth analysis of her initial application for permission to appeal in our video Lucy Letby Court of Appeal Super Expert. We also covered the subsequent updates in our video Lucy Letby New Developments and Thirlwall Inquiry Impact. Both are linked in the description below. We do not propose to repeat this here and recommend that you watch these videos for background information purposes. Turning to recent developments, we must first address her application for permission to appeal the conviction from her retrial, an application that unsurprisingly was destined to fail. This outcome was predictable given the prior refusal for permission to appeal the convictions from her first trial, as well as the sole argument put forward. This is a stay of proceedings on the grounds of abuse of process. Such a stay is widely regarded as a remedy of last resort, making it exceedingly difficult to succeed. But let's go in stages. In short, the Court of Appeal heard the application on the 24th of October 2024 and handed down the judgment on the same day. The hearing was short, covering barely 2 hours. And as mentioned, Letby's notice of appeal covered one single ground. That is that the trial judge erred in refusing to stay the proceedings. In a preliminary application heard in June at the start of the retrial into Baby K, the defense argued that given the extensive publicity surrounding the first trial, Ms. Letby could not receive a fair trial, making the retrial an abuse of process. They further contended that staying the proceedings was necessary to protect the integrity of the criminal justice system in light of the unprecedented conduct by the police, the prosecution, and other prosecution witnesses who readily released comments and interviews across various media platforms following the first trial, especially in light of their knowledge that a retrial was a possibility. This behavior by those involved in the prosecution process, said the defense, offends the integrity of the criminal justice system so as to require a stay of the proceedings. By way of background, it is an established principle in English law that the power to stay criminal proceedings as an abuse of process is an important, though exceptional, remedy to be exercised with care and restraint. A stay of proceedings is the exception, not the rule. It is a measure of last resort. The court has the power to stay proceedings in two categories of cases. One, where it would be impossible to give the accused a fair trial, and two, where it offends the court's sense of justice and propriety to be asked to try the accused in the particular circumstances of the case. In the first category, if the court concludes that an accused cannot receive a fair trial, it will stay the proceedings and not question of the balancing of competing interests arises. In the second category, the court is concerned to protect the integrity of the criminal justice system. Here, a stay will be granted where the court concludes that in all the circumstances a trial will offend the court's sense of justice and propriety or will undermine the public confidence in the criminal justice system and bring it into disrepute. The balance must always be struck between the public interest to ensure that those who are accused of serious crimes should be tried and the competing public interest in ensuring that executive misconduct does not undermine public confidence in the criminal justice system and bring it into disrepute. First, it must be determined whether and in what respect the prosecutorial authorities have been guilty of misconduct, such as very serious examples of malpractice or unlawfulness, as opposed to state incompetence or negligence. It is also accepted that misconduct is not the only basis, but it is clear that it has to be something out of the ordinary. Secondly, it must be determined whether such misconduct justifies a stay on the ground of abuse of process. This requires an evaluation on the particular facts and circumstances of each case, weighing in the balance the public interest in ensure that those charged with crimes should be tried against the competing interest in maintaining confidence in the criminal justice system. In the Lucy Letby case, regarding the first stay application, Judge Goss dismissed concerns over extensive prejudicial media coverage, reasoning that the fade factor diminished its impact by the time of the retrial. He concluded that any potential unfairness could be addressed through instructions to the jury to focus solely on the evidence presented in court. For the second stay application, Judge Goss ruled that the actions of the police and prosecution after the initial trial did not constitute misconduct. He determined that any resulting unfairness could be managed through cross-examination of those witnesses who participated in the media coverage. In relation to the first case, the Court of Appeal agreed with Judge Goss's approach, and though it found that the outcome of the first trial undoubtedly led to an unusually large amount of publicity and online debate, it also found that by the time retrial took place, the fade factor would have been significant. From the 25th of September 2023 onwards, the reporting had been limited. What would remain in jurors' minds would be the fact of Letby's offending, which in any event was in evidence before the jury in the form of previous convictions. The Court of Appeal found that since the convictions were in evidence, the publicity was of far less effect. The prejudice came from the jury knowing that Letby had been convicted of 14 offences of murder and attempted murder. Now, putting aside our opinions on the case and the questionable evidence presented in the initial trial, we actually agree with the approach taken by both Judge Goss and the Court of Appeal on this specific point. If we are committed to open justice and trial by jury, then we must accept that publicity and public commentary will naturally follow a trial. We must also trust that a properly instructed jury in a retrial can responsibly disregard external influences. However, we take issues with the second part of the argument. Although the Court of Appeal acknowledged that Dr. Jairam's testimony was central to the retrial, it concluded that his post-trial conduct could not have prejudiced the case against Letby. After a detailed review of Dr. Jairam's statement, the Court of Appeal found no significant departure from the evidence he presented in both trials. In our view, however, Dr. Jairam's post-trial conduct is rather relevant under the second category of abuse of process. We believe the issue wasn't whether his account differed, but rather that he was allowed to comment on a case in which the jury had not reached a verdict, resulting in no conviction. We agree with the defense that it is exceptional for a witness to publicly discuss a case without a conviction, and for the prosecution not to restrain him, particularly since a retrial is a possibility when a verdict is not agreed. Given the critical role of Dr. Jairam's testimony in the retrial, his conduct after the first trial, unchecked by the prosecution, was enough to offend the court's sense of justice and propriety, while also undermining public confidence in the criminal justice system and bringing it into disrepute. If we weigh the public interest in prosecuting alleged offenders against the equally important interest of preserving trust in the criminal justice system, in our view, the latter should have prevailed in this specific case, given that Letby was already sentenced to 14 whole life terms. On that basis, in our view, the retrial should have been stayed. The fact that the Court of Appeal emphasized how in cross-examination the content of Dr. Jairam's interview was used to make a forensic point on behalf of Letby does not change the position, as though this may have mitigated the prejudicial effect of his interviews. It has no bearing on the interests of preserving trust in the criminal justice system. In relation to the second category of abuse of process, the Court of Appeal did not agree with the defense contentions that the police had embarked on a media campaign in emotionally charged circumstances. It found that the position had been overstated and that nothing said by the police officers went beyond what would have been apparent to the jury as soon as they were told of the nature and extent of the other offending. The judge identified that to stay a criminal trial because it would offend the integrity of the criminal justice system always will be the remedy of last resort. It is an exceptional step to take. It was not justified by the circumstances in this case. The judge was entirely correct to find that it would not be unfair to try Lucy Letby for the single offence of attempted murder. It follows that we refuse her application for leave to appeal against conviction. We repeat what we said earlier. This application related to a narrow legal issue. Nothing we have said can contribute to any debate about the wider case against Lucy Letby. With the exception of the point we made in the case of Dr. Jairam's testimony, we believe that the Court of Appeal's ruling was well reasoned and also clearly stressed and recognized its limitation, given the narrow point it was asked to deliberate upon. We reaffirmed that open justice and trial by jury are essential principles we must uphold, even in the face of media coverage. Trials must continue regardless of public or media interest. However, restrictions on coverage at critical moments can be harmful and should be imposed only in rare and exceptional cases. In our view, the restrictions placed on the Letby case at that late stage, in September 2023, only served to stifle the few emerging cautious comments supporting her and any debate over the questionable evidence presented at her trial, rather than curtailing the widespread negative commentary already pervasive on the internet. In fact, allowing and restricting discourse might better serve the interests of justice, enabling both supporting and opposing perspectives to be heard. And what do you think? Let me know in the comments below. Now, moving on to other matters concerning this case, which we will address briefly as they have been covered widely by the mainstream media. Despite both applications for permission to appeal having failed, concerns around the case have only deepened. Early last month, The Guardian published an article highlighting new issues. One notable detail was that early in the Lucy Letby's investigation, Cheshire Police pursued a line of inquiry regarding the validity of the statistical evidence in the case. To explore this, they consulted Jane Hatton, a professor of statistics of the University of Warwick. However, this line of inquiry was later abandoned on the CPS advice. According to The Guardian, these events were never disclosed to the defence. The article also included a retired nurse's account of the existence of another entryway to the neonatal unit leading to the back staircase. She said the door had a keypad system still in place when Letby worked there, so no specific staff data was recorded from it. She added, "To me, even without the discovery that they used it in the wrong way round, the swipe data was worthless." Additionally, the article reiterated another concern about the medical evidence presented, which was largely downplayed and dismissed by the Court of Appeal during the consideration of Letby's first application for permission to appeal. A report by Dr. Evans dated August 2022 suggested the baby's death was caused by air injected into the stomach via a feeding tube. Evidence in the form of an X-ray taken on the 12th of June 2015 was adduced in support of this theory. However, it was later revealed in court that Letby had no contact with baby C until the day after the X-ray was taken. Consequently, Dr. Evans changed his position at trial, suggesting the air had instead been administered intravenously on the 13th of June, causing the diaphragm to splint. In line with the swipe card issue, this issue was said to have no bearings on the outcome. So we are being told, sure, there was an error here and a change of heart on some evidence there, but hey, none of it impacted the outcome. Make of this what you will. How appropriate when we are in fact addressing the criminal justice system integrity. Meanwhile, it has come to light that the barristers representing the parents at the Thirlwall inquiry have taken the liberty to attribute incidents to Letby, including those in which she was either found not guilty or for which the jury reached no verdict. These raises serious concerns, and in fact this led Letby's new lawyer Mark MacDonald to apply for Lucy Letby to be legally represented at the inquiry, arguing that her involvement should be subject to fair representation given that the investigation remains open. The inquiry, however, we understand, declined his request, citing potential disruptions. This decision appears questionable and irrational. At minimum, reassurance is needed that the inquiry's mandate, as emphasised by Lady Justice Thirlwall herself during her opening address, that the inquiry will not set about reviewing convictions, should also apply to incidents where Letby was either cleared or left without findings. In such cases, the inquiry is bound to explore causes beyond Letby's actions. Commenting on this issue, MacDonald noted, "What we know is that the police have still got an open file on this case, so all this other stuff that is coming out, nobody has ever said that's outside the trial process, and there is no proper evidence. That's why she needs to be represented." He added, "The elephant in the room throughout this inquiry is whether she committed these crimes at all." Furthermore, the inquiry has consistently revealed how many in the management and executive teams were uncomfortable with removing Letby from her duties in the absence of concrete evidence. They repeatedly reported that they were not made aware of certain details that consultants later disclosed to the police or in court. We have previously commented on this matter and have raised questions as to what may have caused the consultants to act in such a manner in our news session In the Name of Justice, linked below. Will we finally hear the reason beyond their decision to withhold information that later in the course of the two trials became crucial and incriminating when consultants such as Dr. Jairam and Dr. Breary will give evidence to the inquiry? Or should we expect more evasiveness as we saw with Dr. Gibbs' evidence? I leave you with that thought today and look forward to your comments below. I hope you have found this video insightful, and if you did, please like it and subscribe to our channel if you haven't already, so that we can grow our community and engage a wider audience in our mission to humanize the criminal justice system. Also, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. Join us again as we sit and rise in this unique trial.